Welcome to the Wills and Estate Transmission Podcast, brought to you by Directives, specialist lawyers in wills and estates.
Hi, and welcome back to the podcast channel for Directives. This is session 2 for Advance Health Directives. We had so much to talk about last time that we ran out of time, so we're at session 2. So welcome back, everybody.
Thanks for having me back. I know that last time we spoke about quite a number of things, particularly why an Advance Health Directive is important, what's different about an Advance Health Directive, a Do Not Resuscitate Order, an Enduring Power of Attorney, and what each of those things can sort of do for you personally. We also went through what happens if you don't have one, but there is still more to cover.
Fantastic. So we'll get straight off the bat. So a great question to start off with. So is an Advance Health Directive legally binding, and do healthcare professionals have to follow it?
Yeah, so an Advance Health Directive is a legally binding document. It allows you to give directions about your future healthcare and special health requirements. If a medical professional is in need of an answer, they'll first consult the Advance Health Directive. But if the issue is not addressed or they're not finding an appropriate answer, then they'll go to your enduring attorneys. Those can be appointed under an enduring power of attorney or under the Advance Health Directive, as we discussed last time. They'll be able to give the final say. The doctor will need to sign a certificate to confirm that you have capacity to make the decisions contained within the Advance Health Directive. So that they can be sure that at the time that you obviously made that decision and that the decision that they are following, that you had the capacity to do so. We always recommend going to your usual general practitioner to have them explain the document to you and sign off on it. This practitioner will be able to give the best understanding of you, your health matters, and what your general preferences are, and be able to therefore, give you the best explanation. To be complete and binding, your signature needs to be witnessed by an eligible witness. So that's a Justice of the Peace, a Commissioner for Declarations, a lawyer, notary public, someone special like that. The Advance Health Directive will apply only if you lose capacity, and that's obviously only in relation to decisions about your health care, unless the directive refuses life-sustaining treatment. In that case, the directive will only apply if specific conditions are met. So the life-sustaining treatment is inclusive of those Do Not Resuscitate orders that we sort of went through last time, and can include things like artificial nutrients, hydration as well. The special considerations required for the Advance Health Directive to take effect, where it refuses that life-sustaining treatment, are if the person's health is sufficiently poor that one of the following situations applies. So there's a few. You have to have a terminal illness or condition that is incurable or irreversible, and it's the opinion of the treating doctor and another doctor, so you need two, to sign off that you are expected to die within a year. Instead of that, you could also be in a persistent vegetative state. So that's severe and irreversible brain damage while your basic bodily functions, such as your heart, continues to beat. Alternatively, you could be permanently unconscious with brain damage so severe, that there's no reasonable prospect of you regaining consciousness, or have an illness or injury of such severity that you'll be likely to always require life-sustaining treatment to survive. So one of those sort of, I guess, options have to be prevalent, and you must also have no reasonable prospect of regaining capacity. And if in your Advance Health Directive there is the refusal to receive hydration or nutrition artificially, it can only be withheld or withdrawn if starting or continuing to give that hydration or nutrition would be contrary to good medical practice. That's a term often used, and there are definitions for it within the governing bodies of the medical community, but it is obviously a strict, set of guidelines required and conditions that need to be met for your Advance Health Directive which refuses life-sustaining treatment to take effect. Okay.
Right. So, do I need to appoint a specific person to the AHD?
You aren't required to appoint anyone under this document specifically. As we went through last time, you may have an enduring power of attorney which does the trick for financial and personal matters. This should be noted in the Advance Health Directive on one of the additional pages. So that's an additional form at the back of the document so that the medical professionals will know who to contact and what powers your attorneys have. But if your Advance Health Directive does appoint health attorneys, your enduring power of attorney appoints financial attorneys, both will need to work together to make sure that your care is optimal and that there's appropriate communication between the two different sets of people. So, for example, if your health attorneys may need medication for you or new clothes, your financial attorneys will have the decision regarding the expenditure on those items. But ultimately, as always, any persons appointed under either document must work in your best interests. So it's unlikely that a financial attorney can say no to a request for a medication expenditure if it's needed for you, or if you do need new clothes, things like that.
Great. So what should I do if I'm unsure about what to put into my Advanced Health Directive?
Yeah, so if you're unsure, your general practitioner is always the first port of call. So as I said before, they'll know you best. They'll know what your past medical history is. They'll be able to explain what the document does and what it could do for you to you best. It should be a general practitioner that you most regularly see. They'll be able to provide you with any information you need and then, as I say, explain it to you best. But if you're undecided about a particular matter that, you know, whether it should be included in the Advance Health Directive or if that's something more suited for a financial attorney, always seek legal advice before putting anything in place. That's the best spot for you to discuss any issues or concerns you might have about appointing someone, because ultimately those attorneys do have final decision making for you in the event that you do lose capacity and you can't make decisions for yourself.
So how do I ensure my Advanced Health Directive is accessible to my family and their healthcare providers? Do I need to let them know in advance? Where do I put the notifications and everything else?
Yes, it's always a great idea to let your key trusted people know where you've stored your documents. At DeGroots, for example, we offer a complimentary storage of your estate planning documents, which does include those Advanced Health Directives and enduring powers of attorney. This can offer you sort of peace of mind in knowing that the appropriate checks are being undertaken when an attorney requests a copy of your documents. So we'll always request authority from the appropriate people, whether that's you while you have capacity or your attorneys with medical evidence to say that you don't have capacity. Having that independent person there can act as a bit of a gatekeeper and ensure your documents are being handled appropriately. You can also obviously store your documents yourself. They should be stored in a dry, safe, secured place. And those key people I referred to earlier should be close family, trusted friends, as many people as possible without obviously, blowing out your secrets. Let them know where everything is stored so that there is someone at all times who can access them if things are sort of dire. Your attorneys will have to sign the document to accept their appointment, so they'll obviously be aware of its existence and should definitely be one of the people that know where the documents are stored. Like I mentioned a bit previously, the doctor that you regularly go to, your local hospital, any other sort of healthcare providers that you regularly see, they should also be given a copy of the document to keep on file. So this can be an electronic scan of it or a certified copy kept in old school paper files. It'll serve to give you and, again, your family peace of mind that when things are a bit hectic in the wake of a health crisis or a significant deterioration in your capacity, somebody in the healthcare system can quickly access your documents and know that they're the right and most latest version. Another easy way to ensure that the documents are accessible is to upload them to My Health Record and any other platforms that health departments draw information from. It can also be helpful to have these documents uploaded to MyGov and other government websites, as well as Centrelink if you're involved in that as well.
So how can I ensure that the Advance Health Directive is recognised overseas?
Yeah, so having a valid statutory Advance Health Directive is the best safeguard available. So we briefly spoke about the different types of Advance Health Directives available in the multiple jurisdictions, but a statutory one is the best safeguard to ensure your wishes are honoured across jurisdictions. We obviously don't have globally unanimous laws, unfortunately. Because of this, each state, country, have their own regulations and requirements surrounding healthcare and the forms associated with it. For example, even within Australia, each state has their own form and is granting attorneys or other guardians, for example, different powers. So if you do have concerns, you should always seek legal advice. Consult a solicitor in the jurisdiction that you're headed to so that you can receive tailored advice about the specific countries or, again, states that you're visiting. It may very well be that the jurisdiction you're visiting or you live in recognises the forms and nominations of another jurisdiction. For example, in Australia, as we know, each state and territory has their own forms, as I've just said. If you commonly travel across jurisdictions or have some other reason for concern in another state or territory, it's a good idea to prepare documents in each of the jurisdictions. However, it's important to note that you obtain proper advice when doing this, just to make sure you're not inadvertently cancelling out another jurisdiction's documentation or the appointments and powers provided under that. So it's important that you're seeking tailored advice from appropriate professionals.
Great, thank you for that. So here's a good one. What happens if my family members disagree with the decisions in my Advance Health Directive? Can they challenge it?
Yeah, so unfortunately families disagree. It's just one of those laws of life. It's just one of those inevitabilities. Sometimes disputes arise when a patient's healthcare team believes that treatment shouldn't be provided to the patient, but the patient's family or loved ones disagree and want that treatment to be given, or the opposite could be true. There have been notable cases in the courts where family members have sought to prevent doctors from withholding or withdrawing treatment from their loved ones. The intention of Queensland law is always to provide a person with the right to make their own decisions about medical treatment. That can be said for all of the states and territories in Australia. But it is important at the same time to ensure that any decisions about refusing or withdrawing life-sustaining measures is a decision in accordance with good medical practice. It's the reason that the requirements for a decision not to receive life-sustaining treatments are higher than decisions about other healthcare matters, which we obviously touched on a bit before. So a failure to comply with a lawful request in an Advance Health Directive can result in both criminal and civil sanctions against a health provider, and similarly an attorney. So if you're having someone appointed under these documents and they're blatantly going against the wishes that you've put in them, that is also quite a serious mistake, I guess, on their part, and can result in sanctions against them.
When I have my Advance Health Directive, can I have a section in there where if certain treatments are found to be ineffective or harmful over time, I can not have those treatments performed on me? Yeah,
of course. So medical technology is changing rapidly, as we know. There's just simply no way to make your Advance Health Directive pinpoint accurate about a specific medical treatment. Now, this may not be ideal, but as I say, medical technology is changing and a certain treatment may not even be available, or, as you say, may be found to be ineffective or harmful over the next 5-10 years' time. What you can do is make sure that your preferences for the type of medical treatment you wish to receive are outlined clearly. So you should note any current treatments you're receiving, and there are sections in the document that allow you to do this. This will show your attorneys what you're currently getting and the type of medical treatment that you're receiving, and make them aware of that. This will allow them to make adjustments as technology progresses and medical research progresses, and if a new treatment becomes available to, say, beat out your current regimen, they're able to put you onto that, provided it's obviously safe and in your best interest to do so. You can also note in the preferences section of the document, which we did discuss briefly last time, that you wish to receive the most cutting-edge treatment that is available at any given time. This will, allow your attorneys to weigh up the pros and cons, I guess, of having you on cutting-edge treatment versus having you on, say, very researched, very established regimens. Similarly, you may wish to have a direction in there that you're happy for your treatment to be changed, even if that meant you were a bit of a test subject, say, for a treatment. Vice versa, if you wanted only very sound and very researched treatments, you can have that in there as well. So it's really up to you what you put in, how specific you are, and up to your attorneys to, again, ultimately have the final say about what treatments are needed for you.
Yeah, I think that's important to say, the final say, because another question that we've got, can I designate someone else other than a healthcare proxy to help make decisions based on my Advanced Health Directive if I can't communicate?
Yeah, so under your Advance Health Directive, you're able to appoint up to 4 people to act for you at any given time. So there is that limit of 4 people. This can cause worry for some people where, say, you have 5 children who wish to be involved in the decisions about your healthcare. In this case, you can record in the document that you wish for, say, well, let's use the children example, wish for all of your children to be consulted in relation to health decisions for you, and that the attorney appointed, whether this is one or multiple of your children, or alternatively an entirely separate individual, seriously considers the opinions of all of your children when making any decision for you. Again, ultimately, the appointed attorney will have the final say and sign off on anything on your behalf, but they will be bound to act in your best interest. So if you record that you wish for anyone else particularly to be involved in decisions, then obviously circumstance permitting, the attorney will be bound by this and by virtue of acting in your best interest should consult those you love, respect and trust.
So talking about that, can I appoint a Minister of Religion to the AHD?
You could, yeah. So if you had a particular religious figure that you wanted to be involved in it, then you can obviously note that in the special preferences section of the document. We're a very multicultural society. Various religious and spiritual beliefs are quite prevalent. For this reason, the documents can be tailored and can meet your needs. It is, in some religious bodies, the belief that transfusions, for example, shouldn't be undertaken. So it's absolutely something that can be noted in the Advance Health Directive, and a religious figure, whether that be one person or a church as a whole, whatever the needs be, can be consulted. Again, it's just important that you note this in the document so that your attorneys are aware. And there are a few sections where you can note specifically what your religion or belief system is, because these are often very impactful on the type or level of healthcare you'd prefer or not prefer.
Well, it takes us to a great question. What are the potential legal or ethical challenges that healthcare providers might face when following an advanced healthcare directive?
So there are often concerns around the ethics of, say, withholding life-sustaining treatments, where a principal has requested this, but the family disagrees. We touched on this a bit earlier. Ultimately, where the decision is valid by the principal, so again, making sure all of those circumstances are met, the principal had capacity at the time of putting the decision in writing, executing your Advance Health Directive, then the doctor is bound by that and must act in accordance with your wishes. Similarly, if a professional administers treatment that you've validly and appropriately refused, they may be liable in criminal or civil law for their actions. I know some of the most notable issues often raised are patient autonomy versus the ethical duty to act in the best interests of the patient, and good medical practice for that matter. The quality versus the longevity of a person's life, and cultural and religious beliefs as well often come into play, as I've just mentioned. So because they're ethical in nature, all of these questions and issues raised, we don't have all the answers. But a case-by-case approach is generally applied for the considerations for all of those sorts of ethical issues. And ultimately, good medical practice, the opinions of your attorneys, and those expressed by you where valid are the deciding factors, really.
Great. Okay, so we've covered a lot of topics in the last couple of podcasts. So would you like to give us a quick recap, Dannielle?
Yeah, so I guess in summary, it's very important to have an Advance Health Directive in place. In failing having that, it is vital that you have an enduring power of attorney put in place for you. So appointing attorneys to make decisions for you under either of those documents, it gives you peace of mind that someone is there to make decisions for you when you are unable to do so, and is able to do so fully informed. So having these enduring powers of attorney, and more specifically the Advance Health Directives, filled out appropriately after receiving valid advice from doctors, from your solicitors, is the importance of it cannot be expressed highly enough. It's vital to have those documents there to protect your attorneys as well. It will give them peace of mind in knowing that you've expressed what you want, and whatever they decide, again, provided it's in your best interests, is final.
Great. Thank you very much.
No problem. Thanks for having me.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.